Okay, I call the Huntington County Board of Zoning Appeals January the 27th to order. First order of business is roll call.
Steve Park,
Here.
Dale Hawkins,
Here.
Kevin DeKine,
Here.
Mike Thompson, Bob Bolin,
Okay, now we already skipped one item that we were supposed to announce that Huntington County BZA is following the Indiana Code 36-1-3 and Huntington County Ordinance number 2026-2. You want testing? Yeah. Yeah,
That's on.
that's on.
Can you hear
Can you
me?
hear me now?
Can you hear me?
Can you
Just
hear
need
us?
to be closer to the microphones, you think? Okay.
Can you hear me now?
Hello?
Must have to yell.
Well,
We're just gonna have to yell.
My voice does not carry well, so.
Pull it.
Don't carry.
Your mouth.
I can hear it fine through the YouTube, but if they can't hear that with the personal mic.
The air's still on. Could that be?
No,
Yeah.
it don't help, but
Right. If we can get that off, I think that will help.
You still can't hear me.
it's just, yeah, that's not a problem at all.
Technology is great when it works.
It's just, if I put it too much, it doesn't keep talking.
Can you hear me? Testing 1, 2.
Go Hoosiers.
Okay.
Okay, we good to go?
We're good?
Good.
You need a motion for
Yeah. Yeah, motion to proceed. Okay. Okay, where am I at here? Declaration of conflicts of interest. And with that, I have a conflict of interest for the Maple Solar Project for Bob Bolin and then also Mike Thompson. They have provided a letter of recusal for that project, and they are being replaced for that docket item. Will be Jim Sproul, which was appointed by the Plan Commission, and then the commissioners appointed Jordan Beaver to that role. So those will be the two persons to fill in for Bob and Mike. And any other conflicts of interest with the docket item tonight? No. Okay. Okay. Kim, do you have their letters, or we have letters from them on that?
I might make a copy of those.
Okay.
I may have gotten an email on those. I don't remember
Okay.
for sure. I don't think I have both of them.
Okay. Let's see. Then consideration of minutes from November the 25th and December the 30th. They were in your packets.
I probably don't.
Yeah. The one item I did notice on the, I think December 30th, yes, December 30th meetings, on the second page, it was a motion and appointment of Robert Kruger. And the motion, it says approved 5-0, and it was 3-2.
Oh, yeah. Okay.
Yeah.
We'll get that fixed. So you can approve those subject to that change?
Yes, yes. So,
Move to approve is corrected.
okay, motion, second?
Second.
Kevin seconds. Any other discussion? If not, all for, and vote in favor, aye?
Aye.
Against, negative? Aye. Okay. They pass as presented with correction. Okay. The next item is administrative items, the election of officers. So look for a motion for offices for chairman and co-chair.
Motion to nominate Steve Park as our
Second.
president.
And second, You gonna stay, Kevin?
Pardon me?
You're a second, are you?
I said,
No, he seconded it before you could even get it
Oh,
out.
okay. Okay.
we didn't give you a chance to.
Yes, okay. Okay, all those in favor by aye?
Aye.
Opposed, same sign. Okay, for co-chair. Kevin, you were it last time. You okay?
I'm good.
Okay. I make a motion that Kevin remain as the co-chair. There's a second.
Second.
Okay, motion second. All those in favor by aye?
Aye.
Opposed, same sign. Okay, we have appointment of secretary, which would be Heather Hagerman and Claudia Moreno.
Moreno?
Okay. So look for a motion.
Motion to accept them as our secretary.
Second.
Okay, have a motion and second. All those in favor by aye?
Aye.
Opposed, same sign. Okay, adoption of 2026 meeting calendar, and note a change. They had from 6:30 to 5:30, and that was to facilitate the security to be more consistent with their time frames.
So move.
Okay,
Second.
okay, motion second. All those in favor by aye?
Aye.
Opposed, same sign. Okay. Moving to new business, docket BZA 25-028, Maple Solar's appeal of executive director's decision to reject the permit, oops, am I right? Yeah. Appeal executive director's decision to reject the building permit application for the solar energy system on property located 3581 East Schaefer Road, Warren, Indiana, to continue to the February 24th meeting at 6:30. Would that be 5:30 now?
Yep, that would be 5:30 now, and we'll need a motion and a second and a vote on that.
Okay. To 5:30 in the GAR room, second floor, County Courthouse, 201 North Jefferson Street, Huntington, Indiana. So essentially, we're moving the docket to February meeting.
Yes. And we'll do a motion and a second and a vote on that,
Okay.
Motion, oh,
to do the continuance.
Do we need, question, do we need to have public input on?
I don't think so on the continuance.
No.
No.
Okay, I didn't think so. Okay, look for a motion.
motion to continue BZA 25-028, Maple Solar's appeal to February 24th at 5:30 PM in the GAR room.
Second.
Okay, we have a motion and a second. Any other discussion? If not, all those in favor by aye.
Aye.
Opposed, same sign. Okay. Okay, moving on to second docket item is BZA-25-027, John Michael's appeal of hearing officer's approval of a variance from development standards for a shipping container on property owned by Todd and Marie Hall, located at 1585 Flax Mill Road, Huntington, Indiana. This being appeal, just for our board understanding, the board is really acting as a judge in this situation between what the director and what was approved, and the Michaels is questioning and appealing that decision. So we're acting as judge between those two groups. And with that, I guess we'll ask for a representative from Mr. Michaels to come up and make presentation. Give your name and address, please.
My name is John Michaels. I live at 3833 North Rangeline Road. Given the absence of two of the BZA members, as well as the unavailability of my attorney to be here, I'm requesting continuance so we can do this right.
To do what?
Requesting a continuance so we can do this right, since we have two BZA members out and my attorney is stuck across the country.
Okay. Okay.
We have a quorum.
Yeah, we have
I was gonna say, we have three, we have a quorum.
Um,
And three can do it right.
Should I do this without my attorney? Is that what's being suggested?
What's that?
Do you want me to do this without my attorney? Is that what's being suggested?
I guess it's, you've had 2 meetings, 2 months of preparation and time for somebody to be here. And do you have your attorney here?
No, he's stuck across the country. He got snowed in and drove, he's in Florida, he can't quite make it back, so.
Yeah, I guess you've had every opportunity to have somebody here at the previous meeting, and you were here at the previous meeting, you're here at this meeting. So I guess I'm not sure what the problem would be.
You have 2 attorneys in your corner right there, I've got 0. It'd be inappropriate.
To clarify, just one attorney. I'm
Yeah.
the attorney for the other. I mean,
Yeah.
I have not missed.
Adrian, any thoughts?
This might be, yes, no. Okay. Thank you. Put it up to you.
So as far as the request for a continuance, gentlemen, for your rules of procedure, it's his opportunity to request that at the meeting, and it is at the board's discretion, so that'd be an item for you all to vote on, if that's something you want to do or not. But as far as the timeline, as recited by Steve, that's right, this matter was set out, I believe, at the November meeting to happen for today.
Okay, I guess at this point now, if you can sit down for a second while we have conversation. I guess with the board members here, you heard what the representation has mentioned. I guess my feeling is that they've had ample opportunity to have somebody here for the meetings. And I guess my personal opinion and feeling is that we should continue on with the meeting and not continue it to next meeting or further meetings. If our conversation.
Agreed, I have no problem with taking this under consideration this evening.
Okay, and I mean, if we were to continue it, I guess my feeling would be to move it to March or April, date to do that. The other issue that's on the table, I guess, there was a letter that was provided by the landowner, and that has a container that wishes not to be continued and wish to get it resolved due to their timing and of being able to proceed or not. So I guess at this point, it's our decision whether to continue or grant the continuance. So look for a motion one way or the other.
Motion to continue the agenda as it's presented today.
Okay, and deny the continuance.
Second.
Okay, have a motion and second. Any other conversation or discussion? Okay. All those in favor by aye?
Aye.
Opposed, same sign. Okay, we're going to continue. With that, if you could give your reasoning, for the basis of why you are asking for the appeal.
I'm here today as an aggrieved property owner and as a witness to the systematic, unequal, and unconstitutional application of zoning law in Huntington County. I'm formally objecting to the approval of Todd Hall's application because the administrative justification for it is a documented self-serving fabrication designed to obscure this board's long history of arbitrary denials against my property and my fundamental constitutional rights. The executive director of the DCD, Kim Hostetler, has publicly asserted that the noise amplification risk of this hard steel shipping container is moot because the owner could legally build a larger pole barn. This assertion directly contradicts the BZA's previous citing of noise as a disqualifier for multiple zoning applications on my neighboring property. While I'm well aware that the BZA threw everything at the wall to see what sticks, that does not change the fact that you specifically cited noise as a reason for denial on multiple occasions. Inconsistent applications of Huntington County zoning laws are not an accident. They're a blatant abuse of discretion. You set the precedents at my previous hearings at the expense of all Huntington County residents. The entire purpose of having laws and processes is to ensure consistent application of societal standards, especially when constitutionally protected rights are involved. Your actions were unethical and illegal. Kim Hostetler's justification is not merely inaccurate and hypocritical, it is a deliberate subversion of the Unified Development Ordinance. This board knows or should know that the UDO was specifically amended with ordinance number 2023-01 to create section 714, shipping containers and other non-conventional structures. A conventional permitted pole barn is not a non-conventional shipping container. The director is attempting to erase a specific, carefully drafted ordinance by inventing a false legal equivalence, a clear act of abuse of discretion, and a deliberate failure to enforce the law as written. The law was created to protect neighboring residents from unwanted negative impacts. By giving special treatment to my neighbor and denying me the protections that were specifically designed by this ordinance, Huntington County is continuing the blatant pattern of favoritism and discrimination that it embarked on starting back in 2019. Since the UDO explicitly treats shipping containers differently than pole barns, this administrative decision is a subjective, politically expedient act of favoritism and designed to grant a non-conforming use that is completely out of alignment with the BZA rulings on parallel applications. The BZA has established a two-tier system of justice, one standard for favored applicants and an unconstitutional standard for those exercising their rights. The common denominator in my denial is a fraudulent noise standard. In 2019, my lawful revenue-generating range application was denied with citation of vague, inconsistent concerns over impact on noise. I challenge the BZA staff again, please identify the specific, measurable Huntington County noise ordinance used to deny my application. You cannot because it does not exist. My denial was based entirely on the subjective opinions of the board, not on law. In 2022, my application for indoor airsoft target shooting in the middle of a 15-acre square was denied after the BZA allowed my neighbor, Joel Jarabek, to offer extended, unchallenged testimony that was entirely speculative and emotional, claiming the noise generated by indoor airsoft would be louder than farm trucks and farm equipment. This neighbor and others claimed that this noise didn't belong in a nice, quiet neighborhood. One of my attorneys and I pointed out that I do not live in a neighborhood or city limits. Yet my neighbors, including Todd Hall, then performed a dramatic act insisting that I lived in a nice, quiet neighborhood. Let's look at the record of this BZA's procedural misconduct on the subject. March 22nd, 2022 hearing, timestamp of 30 minutes, 22 seconds. Todd Hall said, "Headlights flashing around the neighborhood, you know that's the main concern I have." March 22nd, 2022 hearing at 54 minutes, 59 seconds. Todd Hall said, "It is a neighborhood." March 22nd, 2022 hearing, 55 minutes, 42 seconds. Todd Hall said, "We do have a neighborhood, I just wanted to make sure that's clear." March 22nd, 2022 hearing, 56 minutes, 38 seconds. Tom Lund said, "I live right across the street, we do have a neighborhood." March 22nd, 2022 hearing, 58 minutes, 5 seconds. Kim Hostetler said, "This would change the character of the neighborhood." This board accepted that unsubstantiated, non-factual noise hyperbole as a legal basis for denial. During the official BZA decision-making at the March 22nd, 2022 hearing, at 1 hour, 4 minutes, 28 seconds, Jim Sproul stated, "Would not be in harmony with the character of the neighborhood. The additional noise caused by shooting within the metal building would also be detrimental to the residential area." Jim Sproul specifically cited noise as a justification for disqualifying my application, even though this would fail the court's reasonable person test. Any reasonable person would admit that airsoft could not possibly be heard through an insulated walls, let alone across a 15-acre square. The allowing of Joel Jerebeck's absurd claim that indoor airsoft would be louder than farm equipment is just another egregious display of the good old boy system and being valued higher than actual evidence. Yet, while these favored neighbors were fabricating the existence of a neighborhood to use the fear of noise as a legal tool, I went to great lengths to dampen noise caused by one neighbor's rock band practicing, another neighbor throwing chopped wood into a steel shipping container, and several neighbors running farm equipment and construction equipment at odd hours of the night. At the October 16th, 2025 BZA hearing, I pointed out that steel shipping containers amplify noise. I explained that hard materials amplify noise. The fact that steel shipping containers amplify noise went uncontested by both Todd Hall and Kim Hostetler. Todd Hall replied, "From that standpoint, when I put a 120-foot pole barn up, that's the same material steel. I mean, this isn't even going to compare to that." I see a parallel there because I can legally shoot on my property, and yet a lesser regulated version wasn't even given a realistic chance. It was just a kangaroo court. Today, this board is put in a position to approve a hard steel, non-conventional shipping container that, by the executive director's own admission, creates a noise amplification risk, yet the risk is suddenly declared moot. This demonstrates the Department of Community Development and members of this board hold a higher, stricter noise standard for indoor airsoft and Second Amendment activities than they do for an outdoor steel shipping container. This is not zoning, it is viewpoint discrimination and a clear equal protection violation captured live for the public record. The BZA has not only failed its administrative duty, but has actively discriminated against a citizen attempting to exercise and comply with the law. The discrimination is further evidenced by the existence of 5 commercials taking place during my hearings. The first instance was at the February 25th, 2020 hearing, 1 hour, 44 minutes, 20 seconds. Chris Wilson did a commercial on behalf of Greg Parker's Hillside Shooting Sports and distributed a handout advertisement for Hillside. Having competition in a free market is not a valid reason to prevent a business from existing. It's oftentimes called communism. That commercial and the 4 others should have never been allowed to take place during my hearings, yet the BZA did nothing to interject. Some Huntington County citizens may wonder if anyone received any consideration for allowing these commercials during a public hearing. At the November 25th, 2025 hearing, 54 minutes, 41 seconds, I asked the BZA if I could promote my business at the hearing. Steve Park interrupted me by saying no without any explanation of why Hillside and Molly Sparks were allowed to promote my competitors' businesses 5 times without interruption. I came to this body in good faith twice, seeking regulation for a Second Amendment commercial activity. Twice, the BZA chose corruption and discrimination over due process. You were given an opportunity to regulate my activity, to set limits on noise, caliber, number of guests, and hours. You refused. I'm legally entitled to shoot on my property, and I will be building more than 1 range now. Due to the BZA's arbitrary, unconstitutional, and indefensible actions, those ranges will legally operate with no limits on caliber, rate of fire, number of participants, or hours of operation. The ranges will serve as a constant, permanent reminder to the good people of Huntington County of the illegal and unethical acts committed by this board and my neighbors. We will exercise our full rights to file suit against these unconstitutional acts at every opportunity. If Todd Hall is granted this approval based on a discredited administrative lie, it serves as final, irrefutable evidence of the arbitrary system that denied my constitutional rights. By demonstrating unequal application of zoning law with a clear habit of discriminating against Second Amendment activities, you will be qualifying the continuing violation doctrine. In other words, you will reset the clock on the statute of limitations for every single violation of my constitutional rights throughout my history with this BZA and DCD. I reserve the right to exercise all legal redress to pursue any remedies I may have. I ask this board, will you take this opportunity to finally uphold the law or confirm your role in the system of corruption?
Okay, I have a few questions. One, the issues that you're actually talking about specific to the shipping container being on the site is noise, so you're saying? And then-
Yes.
and
Have you had a chance to review the October 16th, 2025 hearing that we're appealing, or was that unavailable?
the what? The
When we had the-
hearing officers?
Yes.
Yes.
Okay, yes, I made the argument in there. You know,
Okay.
this ordinance was made specifically to provide protections to the neighbors, but now that's being taken away from me.
Okay. That's fine, I'm just trying to, I want to make sure that I'm understanding what you're saying. And then the other thing that I got is you're saying that we cannot change the ordinance because the ordinance says it can't be there, so it can't be there.
There was an ordinance established. It was important enough to establish it to protect the citizens, but now it sounds like we're just yanking my protections from it. To explain the noise part of it, hard materials amplify noise, soft materials dampen. This is effectively a steel drum right next to farm equipment, a rock band, shooting activity, plenty of noise. It amplifies it quite a bit, and there's already construction equipment and farm equipment in the middle of the night, which that's a part of being in the country. But amplifying it isn't. There's specifically an ordinance for it.
That's fine, I just want to make sure I got down your points here. Was there, I guess, is there anything else? I mean, what other issues is it in?
Blatant favoritism isn't a comfortable thing. I went to great deals to dampen noise. I've done decibel testings, and these folks have just cried and cried that there's going to be so much noise, and yet they're going to amplify noise, and they don't seem to care about that.
Yeah. Okay.
It's very
No, that's fine.
hypocritical.
Again, I'm just trying to get my points here. Is there anything else that I'm missing? I mean, I've got noise issue, the right that we can't change something that's in the ordinance, and the favoritism. I'm not sure how we deal with that, but.
Consistency would be important.
Yeah.
If you guys specifically cited noise in previous hearings, which you have, you even said that you voted aye when the noise issue came up after it was described as airsoft being louder than farm equipment. Guys, that's absurd. That's inexcusable.
That's not relating to the shipping containers.
It sets a precedence, and
No.
you guys let Joel Jerebeck speak for a long time about precedence, and he was citing cases that had no relevance.
Okay. Is there anything else other than those three items?
Not at this time.
Okay. Okay. You can sit down at this point, and then we'll ask for the director to provide your information as far as the decision.
Yeah, so the shipping container was placed on the property by Mr. Hall without a permit. The contractor was not honest and didn't explain to him that he needed a permit and he needed special approval to have that. So once he became familiar with that, he came to me and we set him up to request the variance. Yes, Mr. Michaels did state all of that at the meeting, at the hearing officer. I simply did not agree with him. I did not find it to be a reasonable concern. The shipping container itself does not cause noise. In fact, Mr. Michaels is the one causing noise with the shooting, and that is a self-imposed hardship. I really don't have much more to add to it than I don't agree with his reasoning for being opposed to it. If he had a reasonable concern, I would have forwarded it to you all right away. That's all I have to say.
Okay. Okay, so we heard both sides. Is there anybody in the audience that wishes to speak for or against this docket item? Provide your name and address, please.
Hank Miller, 5570 North 300 West, north side of town. Just for the record, I want to state that I had a really hard time hearing whether the continuance was granted or accepted. I had to go to the audience, they had to educate me. So pretty much what I want to say. Another thing for the record, this ruling is fundamentally compromised. The board denied a continuation in an active snowstorm with only 3 of 5 present members. The county council canceled last night in the same building, and schools are closed tomorrow. The petitioner's legal counsel could not safely attend. That's all I'm going to say. I want it on the record. It was my opinion that a continuance should have been granted, and the rest of this shows extreme bias, especially from you, Mr. Parker. And I think you guys should go back and think about your continuance, not because I like Jay, but because I'm really tired of the taxpayers getting sued over and over and over again. And this is probably where this is heading. That's all I got to say. Thank you.
There was a vote on continuing, and it was motion second and approved, so, not to continue the docket item, so. I don't know if you can hear it or not. Okay.
That's when your microphones weren't working, you could barely hear.
At that point in time, everybody had said they could
They
hear, I
said you were
believe.
hearing.
So I'm really confused on that.
Turn the volume off, you said you could hear it, and now you can't hear it.
Was the continuance granted or not granted?
It was
The
not
continuance
granted,
was
it
not,
denied.
it was denied. Which,
So my statement still stands.
okay. Any other from the public? If not, we'll close it to the public, and now we're open to discussion of this item. I guess from my opinion anyway, the comments, I just lost my notes, regarding the issues that he has was the sound. And from my understanding, and you correct me if I'm wrong, that this is being used, and the way it sounded in the findings, that this is used for wood storage. It's not anything that's going to be generating any noise. Is that correct? Okay.
That's the way I understood it at the hearing.
Okay. And, okay. Trying to find my other note. There it is. The other was the, I guess, you have any comments regarding sound, I guess? No. Okay.
No, we're good.
Okay. The rights, he mentioned was rights to change the, something that's in the ordinance that's documented there. My understanding, with the ordinance is that the ordinance is a new concern of issues, of the containers becoming more prevalent and more available to the community. And it was an attempt to head off a potential problem, and that the containers on a property was limited and not allowed in various zonings, and this was put in place to help control that in the future. And a variance of development standards is a means to address the specific situations that otherwise is not allowed. So through those findings, the ordinance, even though it says you can allow certain instances to happen within that. And then gives the order and ability to control those items in those situations, whether it's an installation issue, an appearance issue, or a maintenance issue. And I think from what I've seen in the findings from the hearing officer, all of those were addressed within those findings. There was discussion of screening materials that would reduce the visual impact. It was painted to match the adjacent buildings, and and it was not generating any noise to speak of. So it appears like that is correct method of getting a variance of approval on that item. I guess, would you agree, Adrian?
Yeah, I mean, the findings, your process at this point would be to make findings on the three areas. Is it injurious to the public health, safety, morals, or welfare? To make findings on will or will not be will or will not be a substantial adverse impact on the value of the adjoining property owners. And then lastly, will strict application of the terms of the zoning ordinance result in practical difficulties in the use of the property? So as the hearing officer, Kim made findings in a resulting decision. You guys can affirm her decision, you can reverse her decision, or you can modify it to add greater specificity. But that's kind of what you're tasked with tonight as the quasi-judicial job that you have for this evening.
But we didn't, nothing illegal was done in changing the ordinance to allow the container.
No, I mean,
No,
that's
the
part
procedure.
of the reason why you guys exist,
Right.
or
Yeah.
why the variance process exists.
Right.
If something is permitted and a particular property owner wants something to happen, they can apply to Kim.
Anything in this book,
Yeah.
Okay.
This
And ask for
ordinance.
it to be considered to be changed for their specific site
Okay,
based on their reasons, and whether it's the hearing officer or if it's deferred to you as the full board right out of the gate, that decision gets made and your rationale gets trotted out.
Yeah. Good, okay, that's, then I think the third thing that I had on the list that he had mentioned was favoritism, and I guess he cited a lot relating to his past attempt for a facility on the site. That has nothing to do with this docket item whatsoever. As far as, I mean, I suppose you can go with the noise, but the noise is not being generated by the container or by this owner. And there's, I guess, I don't see any favoritism one way or the other regarding it. So, any other
No.
comments or thoughts or feelings?
Seems pretty cut and dry.
Mr., this is not normal. I'll give you the opportunity if you would like to say something additional.
I believe the phrasing used was my application for a facility. I didn't ask you if I could have a facility on my property. I can have a pole barn just like you guys can. I was giving you an opportunity to regulate an activity that could already legally occur there. I also applied for indoor airsoft, so it's not just the range that people keep trying to draw attention back to. It's worth mentioning.
That's fine, but we're talking about something different. We're not talking about your past.
I hear the argument was that because I create noise by shooting, I waive my protections. Is that what I'm hearing?
No, that has nothing to do with anything. I mean, I think the point that was made is you're citing noise reflection from this container being an issue. It's not generating any noise to reflect. You're generating that noise that you're talking about, it seems like.
You're using conflicting words. Generate and reflect are conflicting. And
Either.
yeah, I didn't argue that it creates noise. The wood being tossed into it amplifies.
Steve, whenever let me
Yeah.
chime in at
Yeah,
some point.
And that's fine, but the noise that is being generated to create the reflection is by you, by yourself, so it's self-imposed.
No, it's a combination. You have a rock band that practices across the street, perfectly legal. You've got farm equipment, you got construction equipment. The least frequent would be the shooting. Most of it's going to be the work on the properties and the rock band practice and the tossing wood in there.
not sure what rock band is, but
There's a band that practices in a garage across the street.
on the property where the container is?
Across Flax Mill. So Todd and I are on the east side of Flax Mill. On the west side of Flax Mill, there is a rock band practicing pretty much right on our northern border.
West side of Flax Mill or Range Line?
Oh, I'm sorry, Range Line.
Yeah.
Thank you.
And does that have anything to do with Todd?
Any of the hard materials are going to amplify all of the noise that occurs out there.
Oh,
So it's
I
an
see what you're
amplifier.
saying.
Yeah, it's not like we're plugging in a battery to this container and
that's
it's
not his
generating noise.
fault.
It's amplifying.
That's not his fault that the rock band plays.
It's not my fault either, but if you amplify it, then it would be his fault.
So anybody that put up a fence of any kind would amplify that. If somebody put up a privacy fence.
If it's
along
made out
their
of hard
property, it would
materials.
amplify it.
Right, and so what I'm asking of you is to be consistent with your previous rulings. That was the point of it.
Then the other side of that issue is part of the findings and the direction of this item was to be able to put a vegetative screen, which also deflects or helps with the sound issue if it were an issue. So I mean, it also is a visual screening and it also helps sound. So it seems like it covered it in both situations to me.
There isn't a screen at this point.
Well, no.
The vegetative screen could have been put in before all of this. In fact, it could still be put in while this is taken off-site, but nobody suggested that. We just lead with breaking the law and then asking to be recused of the consequences.
Okay. Yeah. Anything else?
Kim, did you want to say something? Or did
Yeah,
you
whenever you feel it's appropriate.
Yeah. Go ahead.
So just for the record, Mr. Michaels did actually state at the hearing officer meeting that it was his shooting, the noise from the shooting was being amplified by his shipping container. The screening, I really didn't feel that there was a need at all for the vegetative screen. I just did that kind of as a compromise, and he was more than willing to do it just as a compromise in the situation. I really didn't feel that it was necessary. And I think that's all that I was going to say.
Okay. Anything else?
Yeah, there's a shooting range that's been in existence there for just over a century, so I'm definitely not the primary source of that shooting, not that that should ever disqualify me from rights from any county ordinance.
With it, the way I understand it, the screening, landscape screening and the painting of the item was part of the agreement or conditions on that item.
Yes, and, if I had it to do over again, I would have given a timeline of that. Mr. Hall was going to do that pretty quickly until the appeal was brought in. Then he decided to put a hold on the vegetative screening just to make sure that his shipping container could remain, so,
Right.
yes.
What was the level of screening? Was there any
I think we
criteria?
had discussed arborvitaes.
Yeah, it's only gonna be on the south side, which is the narrow side.
Right.
And,
Right.
a couple of bushes. And as the project goes on and I place the pole barn,
I'm sorry, can
Oh, yeah,
you
Todd,
come
if
up
you
and
could
give
come
your
up for the
name and
recording.
address? I'm sorry.
yeah, I mean, completely west of the shipping container.
Name and
Oh,
address.
Todd Hall, 1585 Flax Mill Road.
Thank you.
Completely west of the shipping container is just gravel parking lot, all the way to the property line. So it'd really just be on the south side of it, a couple. And then as I build the pole barn on the west side and possibly on the south side, I mean,
And-
yeah, I mean, it could move too. I mean, it's, I don't have any set plans. I just kind of do this property as I go and make improvements, so. The vegetation screening is kind of funny. I mean, it's a 40-foot shipping container. Compared to a pole barn, it's not even close.
Since you're there, I guess this would be a temporary until that barn was constructed? and
I mean,
spun?
it's up to you. I mean, I really don't care. It'll probably take me 2 to 3 years to get the pole barn done, and like I said, I may do 2. So, you know, once the pole barn's up, I could stick the shipping container behind the pole barn so nobody can see it. I can use the pole barn siding to hide it. I mean, the shipping container is being used to store all my tools and stuff from building my house, remodeling my house, stuff I bought for the pole barn. Eventually, that would be nice to have to store wood in. I've already got it. And it's pretty handy not to put a bunch of split wood in your pole barn. You know, you don't have bugs and stuff, so. Since I had it, but I mean, I'm kind of free going, whatever you guys tell me. I mean, it's just a handy product to have, it's cost effective. And, you know, if I can keep it, I'll keep it, and if not, I'll get rid of it.
Okay, thank you.
Yep.
So we have to do finding of facts?
Yes, so we'll need to do findings of fact, which is, if there's no other discussion or questions and comments. The findings of fact, in essence, are very similar to what Mr. Havestad just read. You know, it was the findings from the hearing officer. And so we can go down the findings of fact. And number 1 is the approval will or will not be injurious to the public health, safety, morals, and general welfare of the community because consider whether the granting the variance will hurt or potentially cause harm to the community and why or why not, and the harm can befall them.
Will not, as it has a very small footprint and is very unobtrusive to the community.
Okay. Any other thoughts to that? I would add.
Go ahead.
Add to that too, if you wouldn't mind, that you know, the conditions are available to be able to place a structure on that site as an ancillary storage type of facility. So they, not only that, but what Dale mentioned, but also.
Did you get everything?
We've got it on tape. If we don't have it written down, but we'll get it. Thank you.
Any other discussion?
Just that it was a temporary type.
Yeah.
Yes.
Okay, so all those in favor by aye?
Aye.
Okay, opposed, same sign. Number 2, the use and value of the area adjacent to the property, included in the variance, will or will not be affected in a substantially adverse manner because, and consider whether the neighbor property will suffer any major negative impacts, and what impacts can neighbor realistically expect.
Will not, same as 1.
All those in favor by aye?
Aye.
Opposed, same sign. Okay, number 3, the strict application of the terms of the zoning ordinance will or will not result in practical difficulties in the use of the property because considered that difficulties the owners would have developing using the property according to zoning ordinance standards. Remember, higher cost is not an adequate justification for a variance.
Will not, again, because of the small footprint of the structure, and it is a temporary, easily removed structure.
Okay. Any other discussion on
That's
that?
good.
Okay. All those in favor by aye?
Aye.
Aye.
And opposed, same sign. Okay. All the findings of fact are in the affirmative. That would allow us to make a motion and direction on this docket item for or against or conditions, you know, relating to it. I guess one thought would be the conversation of the temporary nature, you know, that we could put a time limit on that before, or that it's removed once the other building is completed things of that nature.
Temporary is a relative term, so,
Well, we,
yeah.
We'll
We'll have to figure that out.
Yeah, temporary is relative, and we could give it a date or a time to
And the-
review.
And the screening.
And the screening is, yes, we can make sure that's,
sure
I
that's-
guess the findings of the original hearing
Right.
officer was maintained, the vegetation screening, painting, and the maintenance and maintaining it over the period. Because they had that in that to come back and review that item of the materials. I guess.
I would, I would recommend that after Mr. Hall gets his permanent structure put up, that he would have no more than 6 months to remove or place the,
Or to get a new permit.
or get a new permit, yeah, or place the container
Inside the building.
inside the pole building.
You know, inside the building doesn't matter.
That's true.
But,
So what are you gonna do about other future projects? You have one
I'm sorry, it's closed at this point. So,
So that would touch on the temporary, like your time limitation?
Yeah, a time
You want to set a
limitation.
time as to the vegetative screening being placed and add any specificity to,
the screening would be immediate within temperature,
As part of
weather
the
conditions.
permitting.
Yeah.
Just for the minutes, though, were you stating that if approved, one of your conditions would be that he has to remove the shipping container 6 months after the completion of the future pole barn?
That's what was mentioned, yes.
Okay.
If everybody's.
That's okay, yeah.
So no time limit per se on that, just 6 months, whenever that would be that he would get the pole barn
Yep.
built, right? Okay.
Yeah, if it's 6 months from now,
Is that reasonable? you
Okay.
think?
or if it's 2 years from now.
So read that back to us.
Well, the condition would be that once the new pole barn is constructed and completed, that he would have 6 months from the, I guess, the date of the final inspection, let's say, to remove the shipping container.
Or
Does that
other,
sound-
or other disposition. You know,
Well,
whether-
I think it's
yeah.
removed, and then,
Yeah.
you know, they can come back and do something different in the future if they wanted, but. And like I say, everything else, the vegetation and screening and painting and.
That was all
that's
part of the
all part
original
it.
permitting.
That would all be maintained, of course.
So that would then also be one of your conditions you're saying, is that it would need to continue to still be maintained, painted,
Right.
and just
Yes.
Yeah.
maintained, okay.
Yeah.
And then Adrian, and I'm just asking for the minutes for that purpose, is that they need to put a time frame on the vegetation, we want to come up with a date, and
yeah,
a
that was the
height
question I
of the
asked.
vegetation,
Yeah,
right?
if they want to add any specificity as to the vegetative screening for a time for that to be completed.
That was all part of the original permitting.
It did not have a timing,
Okay.
Yeah.
and it also did not specify on which side of the building it should be on. I believe, was it, Mr. Hall, you said the south side?
South side.
You know, the visual side to the adjacent property owner. Yeah. And
I
I,
gotta give, it's winter time now, so we gotta get,
June,
yeah, I'd say.
June 15th.
Yeah, we gotta give them time to be able to get it in and have a chance of surviving. So like, it was June, July.
June 15th.
Yeah,
June 15th, you say? Okay.
and then they would need to maintain it also. So I mean, you don't put it in and then let it die and go away, so it needs to be maintained.
We adding anything in there about the height? Are we saying like a minimum height at planting of 3 feet, or anything along those lines, or no?
6 feet.
At the time of planting?
Well, I would say at the time it'd be like 3 or 4
Yeah,
feet, and then
okay.
they could grow to a higher over time. Something that would grow up to 6 feet high, maybe.
Okay.
I think it's gonna grow in time, I'm confused.
Sorry?
This is supposed to be a temporary set of trees, right? So what do
Yep.
you mean it's gonna grow in time? These are contradicting.
It can grow up to 6. It's going to be 3 or 4 to start with, and it can grow.
The trees won't matter, will they?
Why are you suggesting that?
Well, we're putting the trees there to, quote, help
Visually.
satisfy the visual and
And the noise.
if
you-
there is noise, any reduction that it might
Yeah.
pertain to
Yep.
you.
Yeah, I think if we say minimum of 4 feet, you know, at the beginning, and then
At plant-
they're
time of
going to grow.
planting.
Getting kind of picky here.
Well, it's being specific, so there's not an issue. So, any other conditions?
No, that,
Yeah, you're okay, Adrian?
yep, and so based upon that, it seems that you would be affirming the hearing officer's decision and modifying it to include this
Well,
specificity for those
that's
conditions.
our next motion.
Yep,
That'd be
okay.
the-
That'd be the
yeah,
spot that you're at.
For that or not.
Yep,
And deny the appeal.
Either deny the appeal, approve it with conditions, is what our options are essentially. So, if there any other discussion or issues? If not, I look for a motion, one way or the other.
Move to uphold the hearing officer's decision to permit the shipping container on the Hall property and with the conditions of 6 months after a permanent structure is erected and screening of the container with vegetation, minimum of 4 feet.
It was the conditions that we discussed. that
Yeah,
we have written.
conditions we
Yep.
discussed.
Okay,
And that denies the appeal.
okay.
Second that.
Okay, have motion second. Any other discussion? Okay, if not, then I'll call for a roll call vote.
Dale Hawkins,
In favor?
Kevin DeKine,
In favor.
Steve Park.
In favor. Okay. I think that would conclude this docket item, and we are at the point of any discussion from board members. Okay. Discussion from public.
What are you gonna do in the future?
Okay, come up and give your name and address and
Mike Skeens, 1941 Dean Street. I see you guys covering your tail. What are you gonna do in the future so this doesn't happen? You're addressing this issue right now, which is great for these two gentlemen, but are you smart enough to plan in the future and say, okay, there's a certain timeline that you have to have this done? Or do you wait till an instance comes up? But I'm sure they're gonna work out their situation just fine, but you guys are creating problems in the future. My question is, are you gonna have a set backdating schedule? Is that something her office can come up with?
Well, I think it's already there.
And why wasn't it followed?
In that, if somebody has a container in this situation,
That
we'd
they
like
were-
to bring that.
That they were supposed to get permission for in the first place?
Correct. They would come to the department, ask what the requirements are.
Okay, so
and-
you gave Todd 6 months to do something. Is the next person gonna be another 6 months, or you can say, no, we kind of like the purple building, we're gonna give you 9 months?
they would come here and it would go through the same process, that.
Well, what I'm
was
saying
gone
is
through
you're not
that they would
smart
ask
enough
for.
to look down the road to get it in place now. You're creating more work for yourself down the road.
It is in place, and the process, correct me if I'm wrong.
Yeah.
Is that you come to the department and say, I want to do this, put a container on the site.
You're not understanding what I'm saying.
I don't think you're understanding. This ordinance has basically all of our rules in it. If somebody doesn't want to follow that rule and they feel they have a hardship to differ from these rules, that's what this board is here for, to, hear their request and look at findings of fact. That doesn't necessarily mean they'll get approved. That's what this board does. That's their job. So-
It just seems in my eyes you're creating more situations.
Every situation's different.
Yeah,
Every,
yeah.
every situation's different.
Okay. Where am I at? Okay, anything else from public? Okay. If not, close it to that. Director's report?
The only thing that I wanted to bring up tonight is just kind of a heads up that it's been kind of a weird year, but we are working through another UDO, Unified Development Ordinance update. The commissioners had contracted with Debbie Luzier to do kind of a second round of updates in the UDO. We meet once a month, just a small group to, she'll draft a chapter and we kind of go through and we discuss those items. So eventually, sometime hopefully this year, we will have our public hearings. We will present it to you, what her proposed changes are to the UDO. So that's just something on the horizon this year in 2026. Just wanted to make you aware of that.
I think too, we're considering proactive ordinances and issues too that's coming up.
Yes, for data centers, battery energy storage systems, and carbon capture. The Plan Commission initiated a future moratorium on those items so that it will buy us, as a county, more time to draft ordinances for those types of activities. So that is on the horizon as well.
Yeah.
Sometime this year, hopefully.
Good. Any other business? If not, look to motion to adjourn.
Motion to adjourn.
Second.
Motion's second, and then all those in favor by aye.
Aye.
Opposed, same sign.